Good morning. This is Max from the Glass Law Group, your Long Island traffic lawyers. We're coming to you today from our Plainview office. The Glass Law Group currently has two office locations, one in Plainview and one in Valley Stream, to allow easy access from those coming from New York City as well as those coming from the eastern part of Long Island, Suffolk County, and eastern Nassau. I wanted to have a moment to talk today about another category or another topic that is a very common in our practice, and that is tickets, traffic tickets that are issued that are actually criminal offenses. Now, in New York, a criminal offense is considered a criminal offense is such when it is a misdemeanor or a felony. There are many traffic tickets that are issued that are either misdemeanor or felony level. They're not all just infractions. Regular traffic tickets, such as blowing a stop sign or speeding, are normally just moving violations and they're considered infractions, which is the lowest form of offense in New York. However, there are some categories of offenses that are serious enough that they rise to criminal conduct, misdemeanor level, which is where you could be sentenced to jail for up to a year, and felony level, where you could be sentenced to jail for over a year. I'm going to talk today about some of the very common categories of and offenses that we receive regularly in our practice. The most common criminal offense that arises out of the vehicle and traffic law, and certainly one that most people are familiar with, is DWI, driving while intoxicated. There are multiple levels of DWI offenses, but at its very base, at its most simple, DWI, driving while intoxicated, is a misdemeanor offense. Now, there is an offense part of the DWI law that's a traffic infraction. That's called driving while ability impaired. However, that is often used as a plea bargaining mechanism, meaning reducing of a DWI to a DWAI. It is quite uncommon that someone has actually issued a ticket for DWAI at the infraction level. When a DWI arrest is made, it's almost always at the misdemeanor level or potentially at the felony level. Now, like I said just before, a DWI, driving while intoxicated, is usually a misdemeanor. However, New York has codified special laws that qualify DWIs as felony offenses, which are more serious than misdemeanors because of the amount of jail that a person could face. DWI felonies in New York often fall based upon prior conduct. So in New York, a DWI may become a felony if you have a prior DWI conviction in the last 10 years. So if you look at the 10-year period, if someone is arrested for DWI, we'll use the same example we use in another video. Someone gets arrested for DWI on July 1st of 2020. If in the time period between July 1st of 2020 and July 1st of 2010, a person had a prior DWI conviction, then the prosecution upon arrest could actually raise the offense from misdemeanor to felony level. This was passed as part of the Leandra's Law package, and in a separate video, we will address specific DWI laws. This video is just meant to give an overview of the different types of offenses in the traffic law that are criminal matters. So DWI is certainly the most common. But besides DWI, there are many other traffic offenses that are actually criminal and people encounter on a regular basis. Another very common offense that we see is called aggravated unlicensed operation of a motor vehicle. What this essentially means is that the police are accusing a person of operating a car or truck motor vehicle with a suspended license. In New York State, it's sometimes baffling to our clients, at least. In New York, if you were to drive a motor vehicle without any license whatsoever, it's a traffic infraction, meaning it's punishable by a maximum of 15 days in jail, but mostly a traffic infraction, just like any other infraction, such as speeding or blowing a stop sign. There's usually just a fine associated with it. So that's what driving with no license whatsoever is. However, in New York, if you drive a vehicle with a license and that license is suspended by the New York State Department of Motor Vehicles, whether it be for high point offenses, failure to pay child support, failure to pay taxes, whatever reason it may be, if the New York State Department of Motor Vehicles suspends your driver's license and you drive and are pulled over driving with a suspended license, that is at a minimum is a misdemeanor offense. Again, under the vehicle and traffic law, driving with a suspended license, just like the DWI to an extent, the offense can be at its base a misdemeanor, but can in certain cases be a felony. There is such a thing as felony driving with a suspended license. The differentiating factor between misdemeanor and felony driving with a suspended license often turns on how many suspensions a person has on their license and on how many dates those suspensions are arising from. In a separate video, we can certainly go further into the differences and the specifics of driving with a suspended license and the ramifications. But sufficient to say, for the purposes of this video, if you drive a motor vehicle and your license is suspended, you are facing the possibility of a misdemeanor or a felony charge for operating that vehicle. Now, a lot of people come to us frequently regarding suspended licenses and say, well, I didn't know my license was suspended, or I got, very commonly, that's because we moved addresses. People come in all the time and say, well, I moved and the DMV, I didn't get the paperwork because I moved and it wasn't forwarded to me. So that's actually not a great excuse to have, because the New York State Vehicle and Traffic Law actually states that you are required to notify the DMV of a change of address. It's your responsibility as a motorist to tell the DMV that you're changing addresses so that they can properly update you with paperwork. So that's a very common um, defense that people have. We have people come in all the time and talk about that, and we normally say, look, that's not really a defense, because you're required by law to tell the DMV that you're moving. So driving with a suspended license, very common, and it's prosecuted on Long Island in the Nassau County District Court on Main Street in Hempstead, at the First District Court in Suffolk County in Central Islip, as well as across multiple villages and towns that have criminal jurisdiction in their courts. They can prosecute you as well for driving with a suspended license. Another very common offense in the same category is driving with a suspended registration. Now, this is not exactly the same as driving with a suspended license, but it is similar. Driving with a suspended registration is normally a misdemeanor offense. Just like with the licensing issue, if you drive a car with no registration on it whatsoever, it's actually a traffic infraction with 0 points. However, if the state has given you the privilege to have the registration granted in New York, and you violate that privilege, essentially, you can then be charged with driving with a suspended registration. How are registrations suspended? The most common way we see vehicles that have suspended registrations is when your insurance lapses. If you have a lapse in insurance, it very frequently will create a suspension on your registration that you have to clear up with the Department of Motor Vehicles main office in Albany. So suspended registrations and suspended licenses are both very, very common. We handle them regularly. They're criminal offenses. They're not of the most severity. However, they are criminal and should be taken seriously. In many cases, it's these types of offenses that ordinary people will have their first experiences with the criminal justice system. Another offense under the Vehicle and Traffic Law that is a criminal offense is reckless driving. Reckless driving can be issued by an officer at their discretion based on the circumstances of the conduct that they witness. So if they see a motorist zigzagging between lanes and traveling at a high rate of speed, while they could theoretically issue the person multiple tickets for individual speeding and moving from a lane unsafely and improper turn signal, whatever it may be, they also have the option, if they believe, to their best belief, that you were reckless in your nature, that is consciously disregarding the laws posted, they can actually charge you with reckless driving, which is a misdemeanor offense. In addition, reckless driving is one of the few criminal offenses that also carries points. Reckless driving is a misdemeanor, and it puts 5 points on your driver's license. There are a number of other lesser provisions, I would say, of the Vehicle and Traffic Law, ones that an ordinary person may not be privy to or understand or know. One of them, for example, is that if you have a suspended registration, you have an obligation to turn that registration into the Department of Motor Vehicles with your license plates. If you don't, and the officer pulls you over, not only could he write you a ticket for a suspended registration, he could also write you a separate ticket for failing to turn in your registration, which also constitutes a misdemeanor offense. Anytime you get a traffic ticket, if it's indicated on the ticket with a little circle that's squiggled in as misdemeanor or felony, you should speak with an attorney right away, regardless. It's our job to determine what the best course of action would be. If you have any questions regarding any criminal offense based on a traffic ticket, Give us a call at any time. We give you free consultations 24 hours a day, 7 days a week. It would be our pleasure to help you. I appreciate everybody watching this video. More will be coming in the coming weeks. I hope you have a great weekend and stay safe out there.